A few notes as we get started here. We have 60 seconds or 60 minutes set aside today to talk about the subject. If you have any questions while we're presenting, please feel free to type them into the Q&A function. We'll try to answer them in real time. If we can't, we'll follow up afterwards. Standard disclaimer that this webinar is for informational purposes only and should not be used as legal advice. So we all know immigration is extremely complicated, especially right now. So if you have any questions on a specific issue, we encourage you to reach out to us via our website or leave your name and number in the Q&A or chat function and we'll reach out to you. As a reminder, today's webinar is recorded. So sit back and relax, and we will also be sending out that recording along with the webinar deck shortly after the presentation today. So a little bit about us, Meltzer Hellring here. We combined an innovative service model, proprietary technology, Voyager, and a creative immigration team to solve immigration issues for corporations, investors, and entrepreneurs. We have about 200 plus active corporate clients. A cross-section of those clients would include Global 200 firms, Fortune 500 companies, and venture-backed unicorns in various industries, including AI, manufacturing, ed tech, and SaaS. We were recognized in 2023 by Crane Magazine as one of the 100 best places to work in Chicago, and we're extremely proud of that. And most recently, we were highlighted in the Illinois Chamber Spotlight 2025 guide and recognized as a top law firm handling quality immigration work in the state of Illinois. A little bit about our service and delivery model. We really focus on these 4 key aspects. One is responsiveness. We respond to clients' emails on average in about 4.5 hours during a business day. We are really efficient as a firm. We open, prepare, and file your transfer cases in about 10 business days so you can get those new employees on board faster. We're extremely feedback focused. And we do this by asking every single client, both human resources, general counsel, the employee that's the beneficiary of the petition, for feedback every time we process a case. We pull those together and form those into what's known as a Net Promoter Score, or NPS score. To date, this year, I believe our NPS score is a 91, and I think it was like 91 or 92 last year in 2024. And then we also not just process cases for our clients, but we really focus on program management, taking the burden of managing your immigration program off you as an HR or general counsel. And we do this through a structured service model that involves a dedicated account team, regular touch points to manage ongoing cases on your accounts, which are typically phone calls, as well as budgeting and any other ancillary services requested by clients. Our presenters today, you've heard the individual working the deck today is Mr. Matthew Meltzer. He's my co-founder and managing partner. Matt, would you like to introduce yourself?
Hey everyone, it's the first and only time you'll hear me speak today, but if you're asking questions in the Q&A, they'll likely be answered by me, so keep them coming. Happy to answer as many as I can, and if we don't get to your question in the Q&A, we will follow up with you if you leave your name. So please be engaged.
Excellent. Thanks, Matt. Move on to me. I've been speaking for the last few minutes. My name is Matthew Hellrung. I am a co-founder and co-managing partner of Meltzer Hellrung. I specialize primarily in scaling immigration programs for our high-growth clients, and this involves immigration policy creation, stakeholder training, and overall account management. And then joining us today is our senior counsel, Michael Tarancik. Mike, you want to introduce yourself?
Hello, everyone. Thank you so much for taking some time out of your busy schedules to join us today. As Matt said, my name is Michael Tarancik. I'm senior counsel at the firm, and I will be assisting him with the presentation.
Great. So I think we'll move on to Voyager. So this is a differentiator for us in representing our clients. Voyager is our proprietary immigration management platform. It's designed to drive efficiency, transparency through the cases that we're processing, and it centralizes all of the immigration information for your corporate immigration program in one spot. It involves core features that such as dashboards for you as HR person, as well as the employees and their families, to provide transparency. We have efficient and automated workflows that help us save time, that are tailored to each case, H-1B, E-3, TN that we process for our clients. The most recent feature is an extensive immigration reporting function in the platform, where we can report on just about any piece of information that's stored in the platform, as well as cases that are ongoing and what stage they're in and when they'll be finished. And then we always strive to provide good information to our clients and their employees. we have a comprehensive knowledge center located in the platform that has all of our webinars, blogs, and some really nicely designed and well thought out collateral that can teach you a little bit about each process that you may be initiating with us, and also helps the employees understand the processes and timelines that we're working with. So the agenda today, we are going to, this is sort of an overview of the general changes that have happened over the last 30 or 60 days in immigration. We're focusing on the ones that we feel impact corporate immigration programs the most. We'll talk about the visa integrity fee and the visa bond pilot program that is soon to be implemented at consulates abroad. The proposed H-1B regulation, which I'm sure a lot of folks on the webinar today want to hear about, as well as the F, J, and I authorized stay changes that are on the horizon. We'll then move on to maintaining status when applying for adjustment of status, which is a significant change that's happened over the last 60 days. We'll touch on the birthright citizenship executive order that just went through the courts not too long ago. Is still kind of in a state of limbo and an injunction, but there's some updates there. And then finally, we'll cover the Child Status Protection Act updates. Child Status Protection Act essentially dictates what child can adjust to a permanent residency based off their status, their parent status, and there's been some small changes there that we'll review. So we'll start off with I'll take this one if you want, Mike, you want to take the next one? The visa integrity fee. Most recently, the Department of State has introduced what's known as a $250 visa integrity fee for non-immigrants of visa applications. This will be paid as part of the visa application process abroad as individuals get visa stamps. It will be charged to most foreign nationals applying for U.S. visas. This includes H-1Bs, E-3s, B-1s, B-2s potentially. And the fee is intended to fund the anti-fraud and program integrity efforts that the administration has most recently implemented. We saw a pause very specifically on the F and J visas for, I believe, 30 days to kind of implement these additional security features. The security features cost man hours and time, and therefore they're bringing it back to the applicant themselves, having to pay this additional fee. Now, the fee is not necessarily permanent. It can be refunded if the visa holder complies with all the terms of issuance of the visa itself and admission into the United States. But TBD, how they're going to implement this, how it will be charged, when and where it will be collected, how it will be reimbursed. There are no details as far as I'm aware at the moment. And then, sorry, we just lost the deck there. Matt, do you have the deck? You might have lost Matt. Hold on 1 second. There we go.
I think we're back.
There we go. And then the impact on international travel and tourism for this fee. You know, travel tourism sector to the U.S. is close to $3.6 billion per year. This additional fee, places a higher burden or hurdle to jump over to get a visa in the to travel to the United States. So overall, with additional fees required, we think that travel and tourism in general will probably decrease a little bit as a result of these, new burdens that folks will have to meet with regard to paying to get into the United States. Mike, anything you think?
Yeah, I was just going to interject a couple of things really quickly. I think I am extremely dubious about this whole reimbursement process. Given the fact that, most visas are valid for multiple years, so it wouldn't be reimbursed until the individual's visa has expired and they've proven they've complied with all the terms and conditions of the visa. So it could be years before anyone applies for reimbursement. And there's no procedure right now for reimbursement. And it could take the State Department years to figure out how to do this. So I would say probably, if you're an employer paying this fee, consider it an expense of the process, unlikely to be reimbursed. And it's going to have a big impact on travel and tourism. I think, frankly, it could deter millions of visitors from coming to the United States, one for the World Cup next year. And we're also hosting the Olympics in 2028. So this is something to monitor. If you're an employer and you're sponsoring an individual who's married and has a family of 4, that's $1,000 right off the top. And as I said, unlikely to ever be reimbursed. So, but let's move on to the visa bond pilot program, which is sort of an old program that's new again. The laws for decades included a maintenance of status departure bond option, which would allow a State Department consular officer to collect a bond that would be, in a sense, insurance that the individual would comply with the terms of and conditions of their status. It hasn't been used. I don't think I've ever heard of it used in the last 20 or 25 years. But in August, the Department of State has implemented a 12-month pilot program. It started just recently and will go on until August 5th of 2026. And if you could move to the next slide. Its purpose is really twofold. It's to try to evaluate whether the State Department can consistently collect a visa bond as a means of reducing overstays. And it's also implemented with the goal of encouraging countries to improve their screening and vetting processes. So right now, it's a very limited program. I think it's really a proof of concept stage, and it's affecting B1 and B2 visitors from countries. Well, it's designed to cover countries that have high visa overstay rates. They don't screen their visa applicants thoroughly by U.S. standards. And in a sort of a little known area, countries that have citizenship by investment programs, essentially where you can invest money in that country in certain designated industries and sectors, and then obtain resident status or citizenship status in this case. But they don't require you to be a resident for any particular period of time. There are several countries that have that particular option. Right now, for purposes of this proof of concept test, it's only applying to countries Malawi and Zambia, two countries that have very low rates of visitors to the United States. Interestingly enough, though, they are not at the top of the overstay rates that the State Department and CBP, Customs and Border Protection, monitor. So it must have something to do with their screening processes, why they were sort of targeted as the first two countries on the list. Can we move on? I think the next slide. Really quickly, how this is going to work when it's implemented. Consular officers, as part of the application process, will determine whether a bond is necessary. They are authorized to request a bond in 3 increments: $5,000, $10,000, and $15,000 increments. There is a pay.gov portal that they will be instructed to use to make their payments. There will be a process for return of funds, but as we discussed in the previous section, the process is in progress at best, and I would not expect those funds to be returned in any reasonable period of time. They are also requiring, again, for this pilot program, that you use one of the 3 airports listed on the slide right there. You can see them. I think, as this program expands, it's going to really have an impact on international travel and business tourism in the United States, and it's going to be a financial burden that may really prevent, many lesser and less and middle income individuals from coming to the United States.
Yeah, I would imagine, if you're flying from China or East Asia, having to fly to Boston, JFK, or Dulles is pretty inconvenient if you're going to California, for example. So yeah. I think there's a hidden additional cost of the airline tickets themselves become more expensive, not just the bonds and the additional fees you have to pay for the visas. So I think you can see here a concerted effort to make it more expensive for folks to enter the United States as a whole and more complicated across the board.
Definitely agree. We can move on.
The proposed H-1B registration rule and FJ and I authorized changes of state changes. Excuse me. So the proposed rule, this has kind of been floating around since the first Trump administration, is a weighted selection process for registrants and petitioners seeking to file cap subject H-1B petitions. Now the cap opens up, if you folks are unfamiliar, every year in March. Generally, there are many more applications or submissions than there are spots for the H-1B lottery. So there's a random lottery done. And then sometime in May, those lottery registrants that are selected are notified via their company accounts, or if you're using an attorney, via the attorney's account. And they're proposing changing how this random selection process works to make it not random at all. The rule cleared final review internally. It has to be published to the Federal Register, perhaps in early August. but the timeline for publication right now is uncertain. Certainly, they would have to probably publish it fairly soon for it to have effect on next year's H-1B lottery. So we're kind of monitoring that very closely. There's a couple scenarios that we see as a firm, with our contacts at USCIS and Washington. One, as I mentioned before, this proposal mirrors the 2020 proposal by the Trump administration before they left office. It ranks or selects H-1B registrants received based on the highest government assigned wage level that the individual is earning. So every time we file an H-1B petition, there's an LCA that's filed prior to submitting the H-1B petition to the USCIS. That LCA requires us as immigration attorneys to take whatever job description you give us and drop it into these occupational buckets, saying that a software developer is most like somebody that has a degree in computer science or technical project management. So we sort of have to take a look at the job, the individual's qualifications for the job, and then pick a bucket we think best represents the position. Within those positions, there are 4 different wage levels that we select. Typically for lottery petitions, because most lottery petitions or submissions are for entry-level folks that are graduating from U.S. schools and already hired by companies in the United States on what's known as F1 OPT or STEM OPT. Those wages are typically wage level 1 or 2, because you don't pay, a newly minted, software developer that's out of a master's program at wage level 4, which would correspond to somebody that may be in the profession for 5 or 10 years or more. So ultimately, the early career professionals are unlikely to be selected in this proposed model, given that their wages will be lower. I would also say that this, in my mind, really affects middle market and smaller market sponsorships for businesses, because I don't think Facebook or Meta or Google or Amazon would have trouble, raising wages to make sure folks get selected. But your middle market and smaller market businesses that are in tech or manufacturing or AI may not have the ability to pay, significantly higher wages to make sure their lottery entrants are selected as part of the process. So we see this as raising the cost of having H-1B employees in general via the salary, and then also perhaps, discouraging or closing off some of the registration process to the middle and smaller market businesses that rely on H-1Bs. There's a second possible scenario that we see here, next slide, and that's a weighted selection based on job level, which I mentioned before. So job level loosely corresponds to the minimum salary that individuals need to be paid, but the salaries can be higher. Level 4 is, perhaps 4 times as likely to be selected as a level 1 wage. Again, they're skewing the ability to receive an H-1B submission and ultimately an approval to folks that are in the higher wage levels and higher salary classifications. This is expected to go through a full regulatory notice and comment process, which I think can take usually minimum 90 to 120 days. Thereafter, they have to respond to the comments, and then the rule will be published at the Federal Register and effective shortly thereafter. Now, we're not sure, exactly when this is going to happen, unfortunately. But we do have some time before the end of the year here for them to get that done before next year's H-1B lottery. Mike, any comments do you have there?
Yeah, a few comments. One, I think we wanted to bring this to your attention because this rule looked like it was going to move pretty quickly through the regulatory process. When it was posted on the Office of Management Budget website that tracks regulations, it moved from pending review to looking like it was going to be published in the Federal Register in a matter of just a few weeks, which is pretty fast for the government agency. So we wanted to highlight this because it did appear that someone in the administration, and his initials are probably Stephen Miller, was interested in trying to have this regulation in effect for a next registration period. It has slowed down. We're not sure exactly why. This is an opaque process within the government until it's published in the Federal Register. But I think it merits, keeping an eye on this and being ready to comment. And to that extent, I'd encourage you all to be active in this. If you sponsor for H-1B visas, this is going to have a dramatic effect on your ability to sponsor early career professionals. And by dramatic, I mean it's probably going to eliminate it for most candidates. Now, a couple of quick comments about scenario 1 and scenario 2. Scenario 1, which was, again, as Matt mentioned, proposed in 2020, is probably illegal. The statute requires that when more registrations are received than there are visas available, it talks about a randomized selection process. Scenario one doesn't do that. And I think when we were commenting or preparing to comment on that regulation 5 years ago now, I think we highlighted the fact that it was going to be subject to legal challenges. That's why we were all fascinated to see that this proposal is entitled a weighted selection process, which suggests that they may do something like, there'll still be a randomized selection process, but if you have a level 4 wage, you have, in a sense, 4 tickets in the lottery. Whereas if you have a level 1 wage, you're only going to have 1 ticket in that lottery when they conduct a randomized selection. So something to be mindful of. I've already heard that some of the impacts of this, as Matt mentioned, small to mid-market employers are going to really struggle to be able to hire and retain H-1B talent as a result of this rule. I think you'll start to see international students more focused on their compensation as they're negotiating salaries with you. And then I think, unfortunately, to the detriment of the United States as a whole, a lot of these very talented individuals whom we've brought in, given them the best education in the world, are going to be looking for jobs in Canada, Australia, Europe, wherever. So this is something that, again, I encourage you to get engaged in. Please contact us. We'll put out a notice when this regulation does get published and describing it in detail. And if you're interested in participating in the comment process, please contact us.
Yeah, I also think it's safe to say that under a possible scenario 1 or 2, there will be litigation around both of these. I believe that may or may not be effective. They could issue an injunction from this rule going into place while the litigation plays out. That could affect this year, maybe next year. So there's a lot to play out here.
Absolutely agree. If there's an injunction or some sort of process delays it, the window is already pretty tight in terms of getting this in place, say by February, which is probably about the time you'd want to publish a final rule affecting a registration process in March. That's probably the deadline. They probably want to do it earlier. So yeah, the clock is ticking.
Mm-hmm. Yeah, and just to be clear, I don't believe you can sue based off the regulation until it's finally published to the register. Yeah. Otherwise, at that point, you don't have standing before that.
Exactly.
So it's something on the horizon, and we can't sue the government for it now. Next slide, please. The F, I, and J change in authorized period of stay. So for those who don't know, and probably most of you don't, because this is a very niche immigration issue, but whenever F and J students come into the United States, they're not issued an exact expiration date on their I-94. They're issued something called a duration of status, or D/S. And what it means generally is that it corresponds to the I-20s that the individuals, the students, are working on, or J interns or specialists that you have are working on, but it doesn't list an actual expiration date, and therefore it makes it a little difficult to understand if individuals are accruing unlawful presence. And just for the person themselves, it's a little confusing when it comes to when does my status actually expire. So the proposed rule is establishing a fixed time period of admission for these F, I, and J entrants, and an extension of stay procedure for non-immigrant academic students, exchange visitors, and representatives of foreign international media. That's the I visa that we're talking about in this solution. Essentially, establishing a status expiration date like you would have for an H-1B, and then thereafter having to file extensions of stay, either with the USCIS or some government agency, we're not sure right now, to continue to maintain their status. Again, this is probably a raise in the bar of difficulties that F, I, and J individuals entering the United States will have. Also, the additional money that would be involved in filing extensions with the USCIS, again, raising the cost of being overall an immigrant in the United States. The 2020 proposal, this is again nothing new. They're kind of going back to the well. Instead of a duration of status, individuals applying for admission in either F or J status would be admitted only until the program end date at their school, noted on their Form I-20 or DS 2019 for J1 holders, and that's not to exceed 4 years. There is a plus 30 days following their program end date for J's and 60 days grace period for F students. Individuals who need additional time would have to file an extension of stay, for example, if their status is running out in F, I, or J. This cleared final review before publication in the Federal Register in early August. but it was recently returned for additional review. Timeline right now, as with the some of the other, the H-1B rule that we just discussed, the lottery rule, uncertain as to when this may be published or implemented. Also, just uncertain as to how it will be implemented. There's a lot of things that go into changing this around, both from CBP, Department of State, USCIS. There's a lot of agencies involved with this.
Yeah, I just have maybe one or two comments, Matt. I think that obviously it's going to be much easier for a young foreign student new to the United States to inadvertently accrue unlawful presence if they don't monitor this carefully and maybe even incur the 3 or 10 year entry bars. I think it's also going to require a lot more administrative work on the parts of school officials, employment sponsors, those who are employing students on OPT or STEM OPT. Those individuals are going to have timing challenges to meet, and they're going to have to make sure that there are no gaps in status, although there may very well, given processing times, be gaps in employment authorization for STEM OPT holders. So I think this is another rule where if you routinely hire and utilize OPT and STEM OPT F1s, that it's something that you need to be mindful of. And we will certainly provide notice on this regulation, and we'll probably be commenting as well. Yeah, go on to the next slide, please. Matt, do you want me to take this one?
Forgive me, I was on mute there.
Okay, go ahead.
Plugging our own content. But if you would like more week-to-week updates, we do these webinars monthly, but we do offer a weekly summation newsletter that covers all of the topics that are changing in immigration. So you can go to our website and register for that. We encourage all of our clients' employees, all of our clients, and anyone that wants to stay up to date on immigration on a week-to-week basis to register for our newsletter, because these topics are always discussed there. And certainly we'll be covering them in the webinars month to month, but if you're looking for something, you want to wait a few weeks, the newsletter is a great place to get breakdowns of what's happening in immigration. So maintaining a valid underlying status. So when someone enters the United States using a visa, let's say an H-1B in this case, they're issued an I-94 with Customs CBP, and that I-94 dictates how long they are allowed to stay in the United States. When it gets close to expiring, as many of you may know, we have to file an extension to maintain that status. Historically, the USCIS would not pursue a removal. So whenever someone falls out of status that the USCIS is aware of, that anybody at CBP or ICE are aware of, they'll issue what's called a notice to appear. That is the very beginning of deportation processes. It basically sets a date at which the individual has to show up to court to plead their case. Now, these have always been issued in a bunch of different areas, but what's new here is they've started to issue them for folks that are on like H-1B grace periods or that are in adjustment of status situations. So that's the difference. We're receiving even a few for our own clients right now. So employees laid off and applying for a change or extension of status during that 60-day grace period, which H-1B employees get, are now receiving these NTAs in record numbers. We have successfully overcome the NTAs by filing extensions or a stay at the USCIS. Matt, I know you had one recently. Do you want to contribute? What was the situation there and how we solved it?
Sure. So this was an individual who had, unfortunately, had done everything right as you would normally recommend, had been laid off, had filed for in her grace period, filed for a B2 change of status to allow B2 as a visitor visa, so allowed to stay for an additional 6 months. While the B2 was pending, had received an NTA. I believe the B2 was eventually approved, and we also filed for an H-1B transfer, and we acknowledged that this NTA existed, but that it really was not worthwhile. That was being challenged in court, and that this person had lawfully maintained status. And then the H-1B was approved with premium processing in less than 15 days. So, the USCIS is, one hand doesn't seem to be talking very well to the other. One hand is notifying agencies to issue NTAs, and then is also approving H-1Bs for the same person. So it's impacting how we are advising clients on what to do about terminations and issuing withdrawals and what to do there. But it is certainly not a bar to hiring either. So if you encounter an prospective employee who has an NTA, you should not necessarily reject the applicant as unhireable. We have already received at least one approval for someone in this situation.
Yeah, it seems that they're harassing folks that may be in these quasi statuses. You're generally, when you're filing an extension or change of stay, you're allowed to remain in the United States while that extension or change of status is pending with the USCIS. It seems the USCIS has decided to issue NTAs in this situation. Pulling back from this, I mean, speaking at a 10,000-foot level, I think this is just designed to harass employees that are on immigration benefits in the United States as they transition from different statuses, which has always happened. Another thing to rattle folks. And these NTAs, I think, I don't know if they're going to go away, but it seems that, we've been successful in overcoming them. It seems to be kind of a paperwork issue to harass folks. Mike, you have any comments there?
Yeah, I mean, just imagine you're a laid off H-1B worker. You're already stressed out. You've got family here in the United States. You're trying to find a way to find another job so you can stay here and your kids can continue to go to school. And then you find out you've been issued a notice to appear to initiate removal proceedings. It's just like the most callous thing that could happen to someone who is, as Matt said, trying to do it the right way. Right? People who filed for a change of status, maybe it's to B2 for a short period, or who have already obtained a new offer and have filed for a change of employer H-1B. USCIS is asking them to leave the country, and so it's really just almost unconscionable what it's doing to the individuals. And it really, this 60-day grace period, which has always been discretionary, but until recently, it has always been granted. So this is a pretty dramatic change of policy that really was never formally announced.
Yeah, and again, if this situation gets more serious, there will certainly be litigation around it to challenge it. We'll have to wait and see how it plays out.
Yep. One last point on this, Matt, is that it's only anecdotal evidence, but consistent with Matt's experience, change of employer petitions are getting approved despite the NTA, and so far, immigration court judges have not expressed any real interest in pursuing removal proceedings when there is a pending benefit request. So hopefully exactly. It's just as you said, Matt, a paperwork circle.
So next slide, please. Just to close this out, consider the impact on timing on terminating, employees that are currently on H-1B or other work visas. And most importantly, when you are withdrawing those petitions, the withdrawal date, the withdrawal itself can be received after the actual last day of termination. They will generally start the 60-day grace period from whenever the last day of termination is, but the withdrawal letter itself, it will likely trigger these NTAs. And it's important, as always, to avoid gaps in status for employees. Especially when applying for adjustment of status or other benefits requests. There's a filing for an adjustment of status, say from an H-1B. The adjustment of status itself gives the individual an authorized period of stay while the adjustment of status application is adjudicated and then ultimately a green card is issued. We always, as a provider, want to maintain that underlying work visa status. I know they're working concurrently and one kind of replaces the other and may be redundant. There's extra cost with filing an H-1B extension when perhaps you don't legally have to, but maintaining the individual's work authorization and underlying visa status becomes even more important in these situations should the adjustment of status be denied or, again, these NTAs continue to be issued.
Yeah, I would agree, Matt. I think what was once recommended, highly recommended, is now required.
Mm-hmm. Next slide, please. I'll take this one, Mike. And you want to handle the child status protection afterwards. Absolutely. So the enhanced vetting of anti-American activities. We saw this, percolate through the media. Initially, J and F visas, which students often come in on, were suspended for a while. And then afterwards, there was this new vetting of social media and everything else. So in August 2025, the USCIS followed suit and updated their policy manual. In addition to the Department of State was sort of already doing this on the types of discretionary factors that affect benefits requests. So essentially they're applying this enhanced vetting that was already happening most recently at consulates to USCIS petitions that are extensions, H-1Bs, TNs, L-1s. USCIS considers whether a foreign national has endorsed, promoted, supported the any anti-American views or terrorist organizations to be overwhelmingly negative discretionary factor. So more or less, they're going to be looking at employees' social media, LinkedIn, TikTok, Instagram, Facebook to see what they're commenting on, what types of organizations they may be associated with, and we're seeing this play out in terms of execution. Most prevalently against folks promoting anti-Semitic terrorism or anti-Semitic ideologies at the moment. So the rule, that I think we've been telling our clients, since January here, but much more recently with the F&J issues, to just stop posting things, unfortunately, on social media that could be considered negative in any way and affect the individual's ability to get an H-1B petition, an extension, and another stay, adjustment of status. For example, the employment authorization applications for H-4EAD holders, national interest waiver applications for green cards, and certainly the EB-5 investor petitions that are run as an investment program, drop off 800 or 1.2 million or 1.3 to secure a green card later on into a regional center approved project. Operationally, again here, additional vetting is likely to impact processing times, both at the USCIS, the Department of State. And we don't see them, staffing up right now to handle this additional vetting. Therefore, ultimately, processing timelines will likely extend as a result of this across the board. Slide, please. Mike, have you handled birthright citizenship in the executive order recently?
Sure. Yeah. This is an update about a change in policy with USCIS. If you could move to the next slide, Matt. That when I first saw it, my initial reaction was, here's a problem. Here's a solution, rather, I should say, in search of a problem. For years, both the USCIS and the State Department, in terms of calculating that Child Status Protection Act wage, which Matt highlighted earlier in the presentation, which establishes the child's age for purposes of eligibility to join their parent on a green card application. That process had always been calculated based upon what was called the final action date that was published in the State Department's Visa Bulletin. About 9 years or so ago, when the State Department went to a two-tiered approach with final action dates and dates for filing, the dates for filing being the new calculation date, USCIS adopted a policy not that long ago which allowed individuals in the United States to file for adjustment of status and therefore lock in their age for CSPA purposes as of the date of that earlier filing date. So it wasn't a massive change in policy, but it was a policy that the agency, and when I was in my last job with the American Immigration Lawyers Association, we talked to them about it. It was designed to have an incremental help to a small group of individuals who are otherwise going to age out under the just extensive backlogs that exist in our immigration system. So it wasn't really hurting anyone because the process that exists, the main process that existed for years, it was just trying to create and carve out an additional option for certain individuals applying for adjustment of status. Well, the administration decided that that was inequitable, that they had to have one policy, and they have decided that as of just a few weeks ago, that CSPA age out provision, I'm talking about CSPA age out provisions right now. I'm sorry. Can we switch to that slide? It's the next slide. I'm sorry, I got the slides backwards in my notes. We'll go to this one, and then we'll come back.
Yeah, no worries.
Yeah. This one, it's really been a minor benefit, but it's helping a significant number of individuals. It applies to individuals filing after August 15th, they're going to be subject to the final action date chart. So that's it for the age out protections for CSPA. Really, if you want to head back to the birthright citizenship EO, there's not a lot of new news. What I thought was interesting here is that USCIS is starting to think about the procedures that it would use to implement the executive order if it is found constitutional. Now, as a practical matter, pretty much every federal court that has reviewed it has said that it is unconstitutional. The Constitution says you're a citizen if you're born in the United States, in essence. But this particular executive order was trying to carve out some exceptions if both parents were undocumented in the country, or if the father was not a permanent resident or citizen, and the mother was either undocumented or on a temporary visa status. So that rule has yet to be the proposal has yet to be sustained by a federal court. There was a Supreme Court decision just a few weeks ago that seemingly allowed it continue, but it was really not on the merits. It was on a procedural issue as to how the issue was brought to the Supreme Court. And the Supreme Court really just said, we don't like the way you're doing it. You have to do it a different way. And not surprisingly, the plaintiffs switched immediately, and the statute is still enjoined, or the provision is still enjoined, and as being deemed unconstitutional. But what the USCIS has proposed is that there will be a registration mechanism for children who would otherwise have no status in the United States, no passport, no status in the United States, to acquire the same lawful status as one of the parents. So if a parent was a TPS holder, then there would be a process for them to acquire a TPS, so they wouldn't be stateless and without status in the United States. So that's really all I wanted to say about birthright citizenship. Keep an eye on it. I think it's highly unlikely that it will be found constitutional, but stay tuned.
Yeah, I think the big thing to pull from that case, really the procedural issue that you mentioned, Mike, was that federal district court judges had the ability to enjoin the implementation of a federal regulation if there was a party that was proved to be harmed. They can issue those nationally, so they can issue a national injunction. The procedural piece that the Supreme Court talked about said that these federal district court judges may be exceeding their power in issuing national injunctions, and therefore may only be able to issue injunctions to cases before them in their districts, whether it's state or circuit. So essentially limiting the power of judges to issue national injunctions, which it makes it more complicated and more expensive. It means you have to bring more suits and more courts across the United States. There are dozens of federal district courts in the United States and almost a dozen circuits. So making it more expensive procedurally to challenge things that the government's doing, revoking some of the power that federal judges at a district level had enjoyed, as far as I'm aware, in history of the United States. Any questions that we can tackle here, Matt, at the end of the presentation? We have about 13 minutes left. We always want to make these webinars as impactful and value add as possible to everybody that's attending. So if there's anything that came up you think it's worth discussing?
Yeah, absolutely. I think the biggest question that came up recurringly in the Q&A was, are there any things that we are advising employers to think about with regards to these new H-1B proposals, about what it means to hire, what it means to guarantee sponsorship in the lottery, what they should be thinking about in terms of securing candidates on OPT?
Yeah, it's tough because we don't know what the role would look like, but I have to say that it may get more difficult to sponsor folks, if you're recruiting them out of school. Certainly, as Mike mentioned, the regulation says that the lottery has to be random in some way. So I think that's where a lot of the legal challenges will be, based. What a lot of legal challenges will be based on at the moment, because it may not be implemented this year, or if it ever is implemented, probably next year. I would say I don't know if there's a drastic need to change hiring practices right now, but be aware that in the future it may get more difficult to move your F1 OPT employees to H-1B. Mike, do you have any thoughts there?
Yeah, the one thing I would add is that I would suspect of the two options that option 2 is the more likely to be the final rule. I think there's a real significant chance that it may not be in final rule form for this year's cap season. So, I mean, I think that sort of begs the question of what is your sponsorship strategy for this year as opposed to years in the future. In the future, things to consider might be, okay, so what salary level could you, within your overall hiring hierarchy, contemplate for an H-1B worker that's non-discriminatory? Also, are there locations where workers, and Matt Meltzer, you and I discussed this, a while back, are there locations where a level 4 wage might be attainable given the company's salary structure and the prevailing wage for that job in the area of intended employment? So there are some strategies to consider, but I think we really do, as Matt said earlier, need to see the regulation, need to see what its provisions are. But it is undoubted, right? So the White House, including the head of USCIS, Joe Edlow, has made it very clear in public that they believe the H-1B program has not been used consistent with its intent, and that it was always intended to be for, quote, those individuals of distinguished merit and ability, which was the old name for the H-1B category, and those who are at the highest levels of their profession.
Yeah, I'd comment, this is going to be a cat and mouse game, where the government makes a move and the immigration community fights back via litigation. There are things that we could possibly do, which would be using, prevailing wage surveys that are outside the Department of Labor's typical wage structure that could, bring wages down. Now, the question is whether the Department of Labor will accept those surveys. We've used them for clients in the past in certain industries. There's a lot to play out here, and I do think that all the great immigration attorneys in the country will figure a way around this one way or another, either through litigation or just this cat and mouse counter move relationship that we all have with the government right now. I know there's a couple Q&A things here. I just want to kind of hit through really quickly because we have about 9 minutes. Someone asked that H-1Bs are not subject to social media checks as a result of the USCIS implementing additional verification checks. They will be subject in the future to social media checks when you file an H-1B extension. So as we mentioned before, have to tread really lightly on who your employees associate themselves with in terms of political views, posts on various social media websites. Unfortunately, this is, I would say, designed to chill speech, which is a constitutional idea, but very much happening right now. Mike, any updates on? Go ahead.
Yeah, one thought I was going to add on that, and it was a topic that didn't make it into the agenda because we put together the agenda before it became breaking news, is that the State Department announced just a few days ago that they are engaging in continuous vetting of visa applicants and visa holders in the United States, including, according to one estimate, 55 million visa holders both in the United States and without. So all of that's going to involve AI, and all of it's going to be involved in searching not just criminal records and immigration records, but also social media. I just think it's inevitable that it's all going to be lumped into one overall effort to find individuals who are in the United States either in violation of law, violation of immigration law, violation of criminal, I should say, immigration law, or who have, again, expressed this anti-American perspective, which anti-American is an undefined term, which could give adjudicators pretty much a carte blanche to define it how they like.
Yeah.
There's a bunch of questions here just about TPS. Mike, you want to take a swing at TPS on Ukraine, Haiti specifically?
So as a backstop, I think the TPS designation in general is waning. I think the administration has made it clear that temporary protected status, in their view, has been misused, that it was supposed to be temporary, and in many cases it has extended beyond that. I don't believe that Haiti is going to be extended. I think that Ukraine is not either. So I think in both of those situations, if you have individuals who are in the United States with TPS, I think that it's really important for them either to find another immigration option, i.e. asylum, or if they're fortunate enough, family sponsorship, or if they're even more fortunate enough, employer sponsorship. But I think that advanced planning, TPS, is in its waning days.
And I would highlight this is why it's really, really important, whether you sponsor work visas or not, that you're aware of who's working for you on a work visa or immigration benefit. TPS, H4s, students, a lot of these things are not sponsored by you, a company. They're provided by the school or by the government because of who the individual is and where they come from. It's really important. We tell our clients, we want to know every single person working for you that's on some type of immigration benefit, because these changes will affect those individuals. We have to know who they are so we can troubleshoot how to deal with these changes in real time and make sure that your employees continue to maintain work authorization. The best way to do this, and we coach clients all the time on this. There are companies that still have problems with this, but getting a really tight grip around your I-9 process, because the documents that individuals give to you to prove their identity and their ability to work in the United States, that's where we can catch a lot of individuals coming into your workforce that are on TPS, that are on F1 OPT, that are on EAD cards from asylum or some type of dependent status that they're in based off their spouse. So the I-9 process is really the bottleneck where you can catch a lot of these individuals who are on immigration benefits that you are not actually sponsoring. And so we always harp on it, whatever you can do, maintain or be aware of these individuals as they're coming into your organization. And, with Voyager, we asked our clients to tell us about these individuals, and then we go ahead and create tracking profiles in our platform so that we're just aware of who's working for you on these various benefits. And if something happens, we can run reports and then pinpoint who may be affected in your program really quickly and pull that to a strategy call to discuss the next steps forward for those individuals and how important they may be to your organization. The increase in H-1B NOID raised signatures. I'm not familiar with this, Matt or Mike.
Yeah, there are not rumors. There are reports in some quarters of USCIS seeking copies of the original signature on I-129 forms. At our firm, we submit hundreds of I-129s. We have not yet received an RFE or a notice of intent to deny asking about anything regarding a signature, but it seems like USCIS is trying to maybe looking more carefully at signatures to see whether or not they are indeed authentic. They're not copies in the sense that creating a digital signature, but you're allowed as of now to present a photocopy of a wet ink signature and only a wet ink signature. And they may be looking to see whether or not there was a wet ink signature somewhere along the way that created the form.
Yeah, I think that's exactly the issue. This is an issue that I think has just sort of exploded over the last few days, where attorneys are receiving notices of intent to deny for their clients, asking for wet signatures, because essentially the rule, and I'm going to paraphrase the rule here, requires either a photocopy or a scanned copy of a wet ink signature to be attached to the petition. Now, my own personal perspective is that aids the agency in prosecution for fraud and misrepresentation. They want to have an original signature somewhere. They don't want to have an auto signature. They don't like to have any of the platforms that allow for click to sign. They want an original wet signature, so it's easy for them to go to a judge and say this person violated the law. We're seeing more of that now. We're seeing the agency start seemingly back away from some policies that had been implementing over the last few years in terms of again, copies of original signatures. So it's something that we're just starting to see and monitor and determine if there is a significant policy shift. One of the challenges right now, this administration is not very communicative with its stakeholders, just not. So it's hard to get direct answers to what would simply be a very direct question to the agency maybe just a year ago.
We have about 2 minutes left, so I want to rip through these. South Sudan and being on TPS, I don't know if we have any updates there. And Mike, I think you talked about the administration's dislike for TPS in general. They have the ability through, basically executive order to cease TPS, to extend it whenever they want. So folks that are on TPS, I just think unfortunately, they're in a precarious position and have to pay attention to the updates that are coming out of the administration.
And I have to admit, I've not been tracking South Sudan carefully. If the questioner wants to get back to me with a question, I'm happy to try to dig a little deeper, but I just haven't tracked that one closely.
Yeah, Anita asked a question here. It would be great to get updates via email on these changes. I would really strongly, as I mentioned before, advise you to navigate to our website and register for our newsletter. Weekly, we put out blogs that update everybody on these changes, what our take is, how you can deal with them. So if you want to get, again, immigration updates on a weekly basis, our webinar is the best place to go to get that done. And then H-1B extensions, transfers, and changes of stay affected by this USCIS ideological screening policy. Yes, H-1B extensions, transfers, changes of status, any immigration petition for any benefit that's filed with the USCIS, for the most part, that affects employment base, is now under this new vetting policy. So that's unfortunate, but that's what the administration is doing right now. And I think that's about it. I just want to remind everybody that we will be sending a copy of the deck that we used today, as well as the recording, to anyone that registered. If you have any follow-up questions for us, please let us know. There's the contact information for Matthew and myself. And if you have something that's more urgent, always feel free to navigate to our website, click the Contact Us button. You can schedule a consultation, and we'll reach out within about 24 hours to discuss what the issue is and schedule that consultation with you. We really appreciate everyone's time today. And we wish everybody a great week, great end to the summer, a very happy Labor Day that's coming up next week. And we will be back next month with more hot immigration topics. Thank you, everyone.
See you next month. Thank you.